Good afternoon and welcome to Antisemitism and the Law, a virtual summit. My name is Matthew Friedberg and I'm a criminal defense lawyer in Toronto. I'm also the legal chair of Hasbara Fellowships Canada. Hasbara Canada is a leading student advocacy organization that trains and empowers students to advocate for Israel at high school, college, and university campuses across the country. Today, we are excited to be hosting our first ever Anti-Semitism and the Law conference, where you will hear from some of the brightest legal minds in the world. You will hear their perspectives on the Ira definition of anti-Semitism and what it means for combating anti-Semitic propaganda. You will also have the opportunity to examine real-life case studies and discuss how you would approach them. Above all, this is a chance to soak in the combined experience of our extraordinarily esteemed roster of speakers. So have your notepad ready, turn up the volume, and join us for an incredible afternoon of education, experience, and growth. I want to take this opportunity to thank our sponsors, participants, and stakeholders of the summit in Hasbara Canada in general. Without your stalwart, robust, and passionate commitment to combating anti-Semitism and supporting our youth, these kinds of initiatives could never happen. Hasbara's mandate is critical to Jewish students' ability to feel free to express their views about Israel on campus, encourage Jewish pride, and have positive Jewish experiences at Canadian educational institutions. As time goes by, the need for Hasbara and its goals only continues to grow. I encourage all of you to do what you can and become more engaged in this dynamic, proactive, and essential organization. Our Jewish youth need all the support and encouragement we can give them, as many campuses have become hotbeds of anti-Israel propaganda. Let me say a few words about Daniel Coren, Executive Director of Hasbara Canada. Working closely with Daniel, I can tell you Hasbara is not just a vocation for Daniel, it's a calling. He understands the imperative of his mission and the importance Hasbara plays in the lives of vulnerable Jewish students on campus. Whether it's a concerned parent calling about their intimidated child fearing reprisals in her grades by anti-Zionist professors because she expressed pro-Israel views in class, to taking on significant issues in the press, Daniel takes on each challenge with professionalism, empathy, and passion. On every problem and project, he goes far above and beyond what one would expect. Very quickly, and as a result of his grit, determination, and intelligence, Daniel has become one of the top leaders in the world of Canadian Jewish advocacy. He is a longtime Jewish community professional, having served in important roles with organizations such as UJ Federation of Greater Toronto, the Canadian Jewish News, and most recently, communications manager for B'nai B'rith Canada, where his focus was combating anti-Semitism and anti-Israel discrimination. Daniel has been published or has appeared in video, radio, and print interviews with Global News, CTV News, The National Post, Huffington Post, Vice News, CBC, JTA, The Jerusalem Post, the CJN, Blog TO, the Toronto Star, the Toronto Sun, just to name a few. As the director of Hasbara Canada, Daniel has engaged Hasbara alumni and students, run tremendous educational events and fundraising campaigns, and is utilizing his knowledge in PR and communications to help Jewish and pro-Israel students find their voice. Please ensure you have your device on mute at all times, as we can't auto-mute you. And now, it is my great pleasure to introduce our executive director, the man that made this all happen, Daniel Coren.
Thank you so much, Matthew, for that incredibly humbling introduction. I truly appreciate it. Good afternoon, everyone. As Matthew so eloquently mentioned, my name is Daniel Coren. I am the Executive Director of Hasbara Fellowships Canada, and I would like to welcome all of you for our Anti-Semitism and the Law virtual conference. This should be a very practical and informative experience for everyone in attendance. I'd like to start off by thanking our keynote speaker, Professor Irwin Cotler, for being here with us today. For all you students, for all you youngins in the audience, today you will have the incredibly rare and unique chance to gain insight from one of the most distinguished Canadian politicians in history. I ask all of you to please take advantage of this opportunity. Please take notes as Professor Cutler shares from his decades of experience as a human rights expert, lawyer, and politician. Today, we will be discussing anti-Semitism in Canada, and in my opinion, there is no one better equipped to speak to these issues than Professor Cutler. I would also like to thank our valued speakers for today, our Nitzana, Darshana, Nitzana Darshan Leitner of Shurat Hadin, Aaron Rosenberg, our wonderful Hasbara alum, who is still very active with our organization today. He's a partner with RELAW LLP, Arsen Ostrovsky, the brand new director of the International Legal Forum, and Benjamin Ryberg, the chief operating officer of the Lawfare project. I would also like to thank all of our very generous sponsors who made today possible: Denton's LLP, Leo Adler Law, Caramana Friedberg LLP, Torrey's LLP, Brooks Business Lawyers, the Paul Bronfman Family Foundation, and Urban Quest Incorporated. I'd also like to acknowledge our partner organizations, the Canadian Jewish Law Students Association, the Jewish Legal Network, the Lawfare Project, the Roel Wallenberg Center for Human Rights, RELAW LLP, and Shurat Hadin. I also have to mention and say thank you to our chair of the board, Dr. Jack Muscat, and his wife, the First Lady of Hasbara Canada, Ruth Muscat. I am proud to say that this initiative, this event, has been years in the making. When I first joined Hasbara some 21 months ago, I was so impressed by the programming that we had to train high school, college, and university students to advocate for Israel on campus. And I thought, what's the next tier for our organization? And I started doing a little research, and I looked into our alumni and learned that out of 800 or so plus Hasbara Canada alumni that we've been working with and that we had sent to Israel and trained them to be advocates for Israel on campus, just over half of those students, more or less, went on to become lawyers, which is really no surprise, given that everything we do at Hasbara is about training students, about giving them the confidence to speak up, to challenge their professors, and most importantly, to have the knowledge and skills to make credible arguments and to affect real and meaningful change. It was with this realization that we decided to create programming that speaks specifically to Canadian law students, that guides them in the art of combating anti-Israel lawfare, that gives them access to important speakers and precedents and case studies, and that prepares them to serve as legal ambassadors for Israel and for the Jewish people, and not just as law students, but as lawyers and as professionals for their entire careers. As we all know, university campuses have become a cesspool of anti-Israel discrimination. There's an incredible bias, and misinformation and propaganda aren't just coming from groups such as Students Against Israeli Apartheid and groups such as Students for Justice in Palestine, but from professors themselves. And I'd like to actually share one anecdote to give you a better understanding of how some of our Hasbara fellows advocate for Israel on campus. One of our most dedicated fellows is a bright young student by the name of Tiphaera Ziner-Cohen. She should be here today, and she will actually be speaking with Professor Cutler later today. Tiphaera, in my view, embodies what it means to be a Hasbara fellow. She is passionate, she is effective, she's a tremendous speaker. She knows her facts and she knows how to argue. I wonder where she gets it from. A few months ago, Tiphaera, who's studying law at the University of Windsor, was in an online class where her professor was discussing the legal rights of the indigenous Métis people. And then out of nowhere, the professor said that the Métis were indigenous to Canada, just as the Palestinians are indigenous to Palestine. Now, for those of you who remember being a student, you probably remember it was very easy to stay quiet, not mention anything, even if you disagreed with the professor. That was probably usually the easier thing to do. And this is precisely the reason why we train our fellows to stand up and to speak out. So Tiphaera, naturally, being Tiphaera and being a Hasbara fellow, challenged this professor on the chat room where all of her fellows and fellow students, could see. She said, excuse me, if you're going to say that, then you should also mention that the Jewish people are indigenous to this land. And in fact, by neglecting to mention them, you're essentially negating their experience. And to this, not only did the professor back down, but other students chipped in and agreed with Tiphaera. Some even messaged her, thanking her for speaking up. In my view, this is how you affect change at a grassroots level. The anti-Israel movement on campus is very real. I do not believe we'll be able to remove every single professor who has a radical and politically charged anti-Israel bias. It's unfortunate, but it's the truth. But what we can do is train students like Tiphaera to educate her peers, educate other students, build coalitions with other students, and combat racism and anti-Semitism together. In my view, that is what real human rights activism looks like, and that's precisely what we're trying to do with our fellows on campus. Fellows such as Tiphaera have been very active also for adopting and calling for the adoption of the Ira definition of anti-Semitism on campuses such as Windsor and many others across Canada, which is why I believe this first session that we will be exploring together will be very vital for other students in the audience and everyone really that wants to understand the Ira definition of anti-Semitism. Our speakers for this session will be Nitzana Darshan-Leitner of Shurat HaDin and Arsen Ostrovsky. Nitzana is an Israeli attorney. She's a human rights activist, and she's the founder of Shurat HaDin, an Israeli law center. She has been leading the legal fight against terror financing, anti-Israel boycott campaigns, BDS, and combating the multitude of lawfare tactics that are utilized against the Jewish state by her enemies. As the president of Shurat HaDin, Nitzana has represented hundreds of terror victims in legal actions across against terror organizations and their supporters. She has also successfully recovered more than $200 million in compensation on their behalf, which is truly something. Arsen Ostrovsky is a leading international human rights lawyer and a voice in the pro-Israel community. He is the brand new CEO of the International Legal Forum, Mazal Tov. The ILF is an Israel-based legal network of over 3,000 lawyers in 30 different countries, with the goal of combating terror, anti-Semitism, and anti-Israel delegitimization and demonization. Arsen has spoken before the UNHRC in parliaments across Europe to audiences in North America, as well as regularly addressing the Knesset. He's considered an expert on anti-Semitism, on the Israel-Palestinian conflict, and on BDS. In 2018, he was awarded the Nefesh B'Nefesh B'nai Zion Prize in Israel Advocacy. Mazal tov to that as well. And I would also like to introduce our moderator for this first session on Ira, Isabella Hazan, another bright Hasbara fellow. She's also our social media consultant here at Hasbara. If any of you students are learning how to advocate for Israel on TikTok, make sure you reach out to Isabella and she'll tell you everything you need to know. Isabella, I will hand it to you.
Thank you, Daniel. We'll jump right into it. The first session on the International Holocaust Remembrance Alliance, IRA's definition of anti-Semitism, the most authoritative definition on anti-Semitism. So my first question to both of you is, why is it important to have a definition on anti-Semitism, and why specifically the IRA definition? Attorney Darshan can go first.
Well, in the what was the beginning of the IRA anti-Semitism definition? After World War II, outright anti-Jewish bigotry became unfashionable. In both Europe and America, memories of the Holocaust were too raw to allow anti-Semites to openly trade in their nefarious ideology. In the academy and the halls of government, the oldest hate had to rebrand itself to remain socially acceptable. So anti-Semites who could not openly express their anti-Semitism turned to anti-Zionism as a way to cloak their degenerate ideology. We don't hate Jews, they say. We only hate Israel. So throughout this, anti-Semites around the world have been able to continue to express bigoted anti-Semitism in polite society will not outright permit. So by substituting the word Israel for Jews, suddenly we have, we actually repeat the Nazi propaganda, but not as well. Israel responsible for the world's armed conflict, they say. Israel exerts a nefarious influence on the world's economy. They've even created a modern version of the blood libel, where anti-Semites several hundred years ago claimed that Jews use the blood for Christian children to bake matzah for Passover, like in 2 days. Today, they claim that Israel harvests the organs of Arabs and sells for profits. So the Ira definition of anti-Semitism and its accompanying examples recognize a simple truth that anti-Zionism is a mask of anti-Semitism, and it powerfully gives an example of anti-Semitism, not to single out Israel anymore. So, for instance, denying the Jewish people the right to self-determination by claiming that the existence of the state of Israel is a racist endeavor is anti-Semitism, or applying double standards by requiring Israel a behavior not acceptable for or demanded by other democratic nations. So the Ihra definition of anti-Semitism is among inter alia against singling out Israel. What nations, companies, universities, academies do not do against Syria, against Yemen, against Saudi Arabia, against countries that totally violates human rights, totally create genocides and other crimes against humanity, but they are singling out Israel. They come and say no more.
Attorney Ostrovsky, what would you say to that question?
Look, first of all, thank you, Daniela, for moderating this panel. Daniel, for the introduction, and especially to the Hasbara Fellowships for all that you do, not only standing up for Israel, but tackling and combating anti-Semitism, and especially, I think it's especially inspiring to see so many young people here today. So I think the fact that you are empowering really not just the next generation of Jewish leaders, but the current generation of leaders, I think is something to be commended. It's also a great honor, of course, as always, to speak in any event with the esteemed Professor Cutler and its honor as well. It's fantastic too. I think it's the first time we are on a panel, so it's great to be on this with you as well.
Good luck with your new job.
Thank you. We'll need it, but look, I'm an optimist. You know, I think Shimon Peres said, "Optimists and pessimists, they both die the same, but it's how we live that determines our path." Look, I wanted to start perhaps just, you know, to frame this. You know, we're talking about especially the Ira definition, and from my perspective, you know, quite simply, unless you can define what it is they're trying to defeat, we have to ask, how can you defeat it unless you can define it? I'd love to refer to there's a famous quote by Jonathan Sacks, of blessed memory, of course, the former chief rabbi of the UK, who recently passed away. And he said in a speech before the European Parliament, I think 2016, when he referred to anti-Semitism as this mutating virus, and this was, of course, long before COVID. And Sacks noted that, you know, something he said was that in the Middle Ages, the Jews were hated because of our religion. In the 19th and early 20th centuries, we were hated because of our race. And today we're hated because of our nation state, the state of Israel. The reality, of course, is that the old hatred never died. It still permeates. In many ways, it's been renewed. But the thing is that it's just expanded and mutated into new forms. Today, it's directed both against Jews as individuals and against Israel, as Professor Cutler, I believe, termed some time ago, against Israel as the Jew amongst the nations. So today, and I think as Nitzana alluded to, it's perhaps no longer fashionable or politically correct, for that matter, to direct your hatred against Jews as individuals. So instead, what is being done today is that those leading today's anti-Semitic charge are becoming increasingly clever, increasingly nuanced, and increasingly manipulative and deceptive in their tactics, which are often masquerading anti-Semitism in purported language of human rights, of international law. However, in reality, these are no more than essentially what I would deem, you know, fake claims and malicious distortions of truth that are disguised as acceptable criticism of Zionism and of Israel. BDS is perhaps the most glaring manifestation of that. It talks about justice, equality, non-violence, and so on, but essentially it is a movement that is rooted in anti-Semitism, in denial of equal rights to Israel, and as Nitzana has no doubt proven beyond very much reasonable doubt, with an unequivocal connection to terror. So all of this, I think, combined, from my perspective, really just underscores the need for an actual definition. And the Ira definition really offers the best, unequivocally, the best tool or guide for elected officials, for policymakers, for authorities, for civil societies, and especially for students such as yourselves here in identifying, importantly, in identifying what is actually anti-Semitism And when you look at the definition, and I'll be happy to expand on it perhaps later if needed, I think it's a definition that is nuanced. It is a definition that is clear, and importantly strikes a very fair balance between what is free speech or hate speech. It covers both classical hatred and modern manifestations. And most importantly, it gives guidelines for when legitimate criticism of Israel, which is perfectly acceptable, but when that legitimate criticism goes over and above the boundary and morphs into anti-Semitism. And examples we've already heard, such as accusation of Jew loyalty, denial of the Jewish people's right to self-determination, which is in essence Zionism, comparing Israel to Nazis, and so on. So it gives very clear examples. And this definition has now been adopted by over 30 countries, including Canada, of course, by a host of multilateral institutions, including OSCE and others, many private, public bodies, sporting teams, and so on. So today, it is the most widely accepted definition, which, by the way, even Bahrain adopted recently following the Abraham Accords. So whereas you're having debates on campuses and elsewhere in some circles about what does fall within Ihra, is it too far, is it not? Here you have now an Arab state, Bahrain, actually adopting the definition in full. So ultimately, I think in order for us to defeat anti-Semitism, or at least dent in it, and importantly change the very narrative and conversation, especially on Israel, requires many steps: educational, legislative, policy, legal, of course, but ultimately it starts with definition. And we need to first identify that which we're trying to defeat in order to defeat it. And that is why the Ira definition is so crucial and so important.
Thank you. In order to fight it, we must understand it and define it. So my next question is for Attorney Dakshan. You've been doing outstanding work at defunding terror. I just started reading your book, Harpoon, by the way. And many students like myself continue to combat against the demonization of Israel on campus. And we recognize the thin line between poorly veiled activism as anti-Semitism. So what do you think is Ihra's role in terms of combating anti-Semitism that stems specifically from the anti-Semitic BDS movement?
Look, I'll tell you, the Ihra definition is a marvelous thing, really. And we're very happy that many countries are adopting it and using it in their policy. However, you can't really fight anti-Semitism or calling to anti-Semitism. You can't fight really BDS or calling to BDS because it's all protected by freedom of speech. And even if you do, and you are trying to do your best by putting fires and fighting against this speech or another, in the end, it's just putting up fires. It's like a guacamole game. Our strategy in Shurat Adin is to fight back, is to go on the offense, is to, whether utilizing the Ihra definition or BDS, or those who want to delegitimize the state of Israel, but not defending the country, but fighting back. And I'll just give you two recent examples that we are involved with. One is the known decision of the International Criminal Court to open an investigation against Israel. For one of the arguments is for building settlements in the West Bank / Judea and Samaria, where the chief prosecutor decided that first it formed a crime, international crime, building settlements in Judea and Samaria. And second, that the court has jurisdiction and can move on to investigate Israel on this crime. Now, why it's really an anti-Semite decision? Because before Israel so-called occupied the territories, before that, there are many other conflicts in the world, more than 100 conflicts of disputed territories that one land claims that the others is theirs. And one land moves its population to live in the land that they conquered, hold under dispute. We have Northern Cyprus as an example. We have Western Sahara. We have Russia occupying Crimea and Georgia. And yet, the court decided to go after Israel from all these conflicts. And it's not that they don't have before them the communications in these conflicts. As a matter of fact, we in Ihra Definition went and investigated and researched this issue and brought communications against Turkey for occupying Northern Cyprus. We proved that they are building houses and universities and give tax incentives to the residents to live in Northern Cyprus, exactly what Israel is doing in the West Bank. And yet, the prosecutor did not decide to go after Turkey, but against Israel. And Turkey is a member in the International Court, and Israel is not. Showing you that when the international organizations want to go after Israel, they single it out, they isolate it, they just pick up to fight against the Jews, against Israel, and neglect the entire world. The other example we are involved with is the UN, is the Human Rights Council of the UN that decided to publish this blacklist of companies, corporations, Israeli corporations that are working in the West Bank, plus Judea and Samaria. Again, the UN came and say that these companies, Israeli companies, have no right to work in Judea and Samaria, in East Jerusalem, in Gaza, in the Golan Heights, because they are occupied territories. The UN comes and decides for the state of Israel where Jews will work, where Jews will have their companies. And I deliberately say Jews because this list does not include any sort of companies, but only Jewish owned, meaning there are many Israeli companies working in Judea and Samaria. There are Arab companies, there are Christian companies, there are Jews companies, there are Muslim companies, but the UN list single out Jews. They just say Jews, Jewish-owned companies cannot work in Judea and Samaria. And we are suing the UN for the first time. We're trying to bring the UN to court to remove its immunity, to come and say that if the UN publish a human rights list, it's actually against the treaty that wars against racism, and they should not be immune. Bringing the UN to court or fighting back against the International Criminal Court by bringing other complaints around the world to show how biased they are and to try to move them from attacking Israel is what we do in Ihra Definition. So you guys, students, and the pro-Israeli community in Canada and elsewhere has to utilize what the law allows, but really to go on the offense. We can defend Israel. We can say wonderful things about Israel. But the only way we can really bring to light what our enemies are doing to us is by fighting.
The offensive is the most proactive approach. Just out of curiosity, has anyone else brought the UN to court?
No. There are several cases here and there, but they all were dismissed because of immunity. UN, according to the treaty, which all the countries are signed on, has immunity.
Wow. So my next question is for Attorney Ostrovsky. You've been doing some very impactful work with the International Legal Forum that combats the demonization of Israel, amongst many other important objectives. So what would you say to those who say Ira silences the criticism of Israel? Oftentimes university students hear this really all the time, and the claims that it's an infringement on free speech. So how can we respond to such criticisms, and why do these criticisms even exist around Ira, a definition of anti-Semitism?
Look, I think, it couldn't be further from the truth. And it's the complete opposite. The Ira definition, I think it actually cements the right for fair criticism of Israel. And I stress the word fair. no one disputes that Israel is in any way beyond criticism. Israel, like any country, ought to be entitled to criticism. The question, however, becomes that Israel is being systematically denied fair and equal treatment in the international community, including some of the forums that Nitzana has spoken about at the UN and elsewhere. But this definition, it doesn't infringe on free speech. On the contrary, it supports free speech. No right is, unlimited. Even in America, which has the Second Amendment right to free speech, that does not allow you, for example, to go into a crowded theater and scream fire and get away with it. This definition is very clear about the instances in which acts, statements, or actions will be deemed anti-Semitic. And it talks about actions like denying Jews' right of self-determination, comparing Israel to Nazis, holding Jews collectively responsible for the actions of Israel, allegations of Jew loyalty. Now, these are by any stretch of the imagination not any kind of reasonable criticism of Israel. It's really, I think it's really attacks and actions that are trying to hide behind criticism of Israel to masquerade their own anti-Semitism. So the question really ought to be asked of those who are trying to water down the definition and actually say that it does infringe on free speech, to ask why is it that they believe that saying, comparing Israel to Nazis or denying Jews' rights of determination is acceptable free speech. So there are limits and there are boundaries. What important distinction we need to make also with respect to the Ira definition is that it doesn't criminalize or punish for anti-Semitic speech or conduct. It only allows or enables, provides a tool, a set of guidelines to determine what is anti-Semitic. It is then up to the authorities to take whatever actions within the realm of the law, including in Canada, within your discrimination practices. I'll give you one example that the International Legal Forum perhaps is involved in, and I know a lot of you in the Canadian community are aware of the case of this lovely cafe food vendors, which they, throughout their Instagram, throughout their social media, and even in the store itself, they posted some of the most obscenely vile statements, everything from Jews not allowed, Zionists not welcome, and so on. Now, this crosses the boundary of any kind of legitimate free speech. This is there was no intention there to have any kind of reasonable discussion or discuss policy. It was very clearly within the realm of also the Ira definition, and there was a tool that was used in order to determine, do these acts actually fall within the criteria of what is and what is not anti-Semitic. This case, of course, is ongoing, so we'll have to see how it progresses. But ultimately, no, the Ira definition does not stifle free speech. On the contrary, it reaffirms the principle of free speech. However, it does draw the boundary where such free speech goes over the limit and morphs or mutates, as Rabbi Sachs had alluded to, into anti-Semitism.
Thank you. And I'm no expert, but I just wanted to touch on Robin's question. I started a movement called Humans for Humanity. It's a movement where we just do good things with other racialized communities, and we're proud Zionists who do it. And I think that just being proud of your Zionist identity, Zionism is a progressive movement, an indigenous liberation movement. So even if they're anti-Zionist, we're often talking past each other. I don't think they contradict. So on that note, I want to thank our amazing speakers, and I'll pass it away to Matthew. Take it away.
Yes, thank you. Thank you, Nitzana and Arsen and Isabella, for that incredible discussion. Ira is without question one of the most pressing issues facing advocates for Israel and Jewish issues today. And the corollary, of course, is that anti-Israel activists have fought actively against the widespread uses of Ira for precisely that reason. In the past, anti-Semitism against Jews was commonplace, but today it's socially unacceptable. So hatred against Jews has been replaced by hatred of the Jewish states. And that's why Ira's definition is so critical. Once again, thank you all for that discussion. Now it's my distinct honor to bring the next panel in, who will be discussing real-life Canadian case studies that will help students examine how the law can come into play as it relates to issues of anti-Semitism and advocacy. Only students will be asked to participate for the workshop aspect of this session. Let me introduce Noah Lewis, an esteemed Hasbara fellow, to take it from here, who will be moderating this panel and introduce the panelists.
Thank you, Matthew. So it's now my distinct honor to introduce the speakers of our next panel, who, as Matthew stated, we'll be discussing real-life Canadian case studies, and that will help students examine how the law can come into play as it relates to issues of anti-Semitism and advocacy. So first up, Benjamin Ryberg is the Chief Operating Officer and Director of Research at the Lawfare project. He received his Bachelor of Arts from the University of Michigan with a double major in Economic and Organizational Studies, and subsequently received his Juris Doctor from the Benjamin N. Cardozo School of Law. He was admitted into the New York State Bar in 2011. Our second speaker, Aaron Rosenberg, is an experienced litigator committed to achieving results for his clients in an efficient, cost-effective manner. He specializes in employment and human rights disputes. He co-founded ReLaw LLP in 2019, leaving a promising Bay Street career behind him to focus on what matters to him most, providing practical front-to-end litigation support to individuals and businesses confronting legal disputes. Aaron's work has been featured in national media, including the CBC, the Globe and Mail, the Toronto Star, and the National Post. Aaron is also a proud Hasbara alum. So, gentlemen, welcome.
Thank you so much.
Thank you. To start us off, I was hoping that you could both each briefly tell us about your experiences combating anti-Semitism throughout your careers, as well as how you guys got involved in this area of law and advocacy. So, Aaron, you want to start off, or Ben?
Sure. Thank you, Noah, so much. I started. I guess it could be said that I was born with an Israeli flag in my hand, and I didn't know it until very later on in my life. But what really sparked my my interest and passion for advocacy was when I arrived at York University, and I saw that it was a inferno of anti-Israel hate. And it was very difficult for Jewish students to navigate those waters. And I had just returned from a year-long experience in Israel, and I was very passionate about Zionism, the state of Israel, and promoting the Jewish community. And so it was at that point when I saw what was happening there that it was very clear to me that someone had to stand up. There were thankfully, I found some advocates that had already been around and already been doing the heavy lifting. And that was a little group of passionate advocates that went by the name of Hasbara. And I became close with them, and I saw that they were these amazing, knowledgeable young students that were super passionate and wanted to advocate on behalf of Israel and fight back against what they saw as bias, unreasonable conduct, and a very heated student environment. It was felt unsafe and uncomfortable for Jewish and pro-Israel students. So I became a leader there, and it was a great experience to meet other like-minded students, and it was really an opportunity to become a leader in the Jewish and pro-Israel sphere. From there, it just grew and grew and grew to the point where it was just clear that I was going to dedicate my career and my future to advocating for those who felt silenced and who needed a strong, passionate advocate. So it was a natural path to law and to litigation. And I feel as though my passions merged so well. But I found myself on Bay Street, and I found myself in a position where I couldn't take on the type of work I wanted to take on. I couldn't advocate in the way I wanted to, and there was so much important work to be done. It's at that point when I joined up with a friend of mine who was also a passionate advocate at York. His name is David, and we became partners, and we started a shop. And our goal was to do litigation, but to merge both our interests in litigation and also in supporting the Jewish and pro-Israel communities and all sort of marginalized communities that need support for these great causes. And so we managed to build a practice that focuses a great deal of time on pro bono, low bono work for the Jewish and pro-Israel community to advance its interests. And that's why that's some of the cases that we're going to be talking about today. And thankfully, I've had an opportunity to work with Benjamin very closely on some of these items. I'm very proud of that work. And you know, my goal is to harness all of my skills and specialized skills in order to promote the interests of the Jewish and pro-Israel communities. And my goal is to inspire others, either professionals or burgeoning professionals, students, to do that in any realm that they find themselves in. It doesn't need to be law. There are so many other spheres where their specialized skills can help.
Thank you, Aaron. And Ben?
Sure. Well, Noah, it's great to finally meet you face to face. I want to thank you for the introduction. Thank you to Hasbara Fellowships for the honor of being able to participate in this conference today. And Aaron, it's an honor to be here with you. As he mentioned, the Lawfare Project and ReLaw have worked very closely and are currently working closely on a number of matters. And I truly can't thank them enough. I mean, this is what we at the Lawfare Project do every day. This is what, frankly, we're paid to do. This is what lawyers like Aaron and his partner David at ReLaw at the firm, this is what they do because they care about it. They don't have to be doing this. It's just so incredible. And we should all be thanking them for devoting their time and resources to fighting the legal fight on behalf of the Jewish community alongside with us. My story was, and how I got involved in this is somewhat more due to chance. When I was in law school, I had a friend that I made in my first year section who started telling me about how her sister was doing work, exposing, doing research and bringing to the public eye, and also doing legal work to address the very serious issue of recruitment and incitement of Palestinian children to become human shields, suicide bombers, etc. You may know the name Brooke Goldstein. This is who I'm referring to. She's the executive director of the Lawfare Project. She is the friend of the sister of my friend from law school. And I started looking into this, and I realized, of course, that this is an incredibly important issue. But it was more surprisingly, I suppose, was that it was getting almost no coverage. Nobody was talking about it. Those who were talking about it, frankly, were getting slammed as being bigoted for saying anything critical about Palestinian governmental policies. And somehow the narrative was always rerouted to attacking Israel one way or the other. So without going too much further into that aspect of it, my friend Danielle and I, Danielle Goldstein, we started a chapter of the Children's Rights Institute, which focused on this issue at Cardozo. We got a lot of people interested, brought a lot of attention to it. And while I was doing this, I started learning more and more about this sort of concerted global effort, whether it was emanating from the UN, from the International Court of Justice, from heads of state, and also just from citizens in the United States and abroad, this really concerted effort to demonize and isolate the Jewish state of Israel. And again, this was something that fortunately I had not dealt with anti-Semitism really in my life. And I came from an area where the Jews tended to be very Zionist and very supportive of Israel. So I simply didn't know what all was out there and what was going on. But as I learned more and more, I became more and more interested about this, and the fact that there didn't seem to be anybody really out there doing anything to fight it proactively. There was some analysis, people giving speeches, that kind of thing, but the problem wasn't being addressed in a way that I thought was effective. So lo and behold, as I was approaching the end of law school and just beginning to study for the bar exam, I'd done 2 summers as an associate at a white-collar criminal defense firm, which was interesting. It was by no means what I was my passion or what I wanted to do forever, but it was interesting legal work. I frankly think if you are care a lot about the law and are passionate about the law, then you can find satisfaction in any number of fields. But criminal defense was sort of not my cup of tea. And at that time, I'd gotten to know again, Brooke Goldstein, better over the years. And she sort of surprised me with this announcement that she was starting the first, essentially a public interest law firm to fight for the civil and human rights of the Jewish people, of the state of Israel, of the Zionist community worldwide. And this was something that didn't exist. Neither of us really knew why it didn't exist when there were entities set up to fight for the legal rights of pretty much every other minority group under the sun, but nothing for the Jewish people, despite the tremendous number of Jewish lawyers in the United States and elsewhere. And so that's what this was going to do. This was back in 2010, and we started sort of looking at what problems existed and what we could do about them. And over the years, we've built it up. We have a network of more than 500 attorneys worldwide now, and they work with us on strategic legal actions that we select to confront the most, what we have deemed to be in consultation with our partners around the world as the most critical threats facing Jewish people today, and the threats that can be addressed using legal avenues. I think for me, and I have former interns who've said this, a lot of people go into this, or those people who do go into this, not that many do go into it, but of those of us who do, I think the more you learn, the more passionate you get about it. And also partly because you realize the extent of the problem and the need for this type of work, but also because you see more and more that if you pursue strategic legal routes, that the results that you're looking for can actually be achieved, and you can make a difference, whether it's combating BDS, whether it's addressing anti-Semitism at universities. I won't go further than that, but using these avenues is really effective, and not just talking about, we're pro-Israel.
Thank you for that, Ben and Aaron. So now I think we'll get into our case studies, as we're pretty tight for time. So for this workshop, I'm going to introduce each of the case studies by providing a brief synopsis, and then I'm going to hand it over to our panelists, who are going to discuss and pretty much provide discuss either to their personal involvement, as was previously mentioned. Aaron's been involved in a number of these case studies, and Ben and the Lawfare project have also been involved in some of these cases. And we'll let them speak to their experience and sort of their own personal involvement, and as well as their analysis and recommendations for the issue. So at any point, if anybody's got anything, we'd like this to focus on students, but if anybody's got anything to contribute, anything to ask, please raise your hand and we'll unmute you so you can, the goal is for this to be as engaging and interactive of an experience as possible. So the first case study that we're going to be discussing is in the province of Ontario, the Student Choice Initiative. So in 2018, the Canadian Federation of Students, which is Canada's largest student union, endorsed the BDS movement and passed a resolution that would pretty much provide funding to different clubs on campus that would endorse and sort of promote BDS. In 2019, the provincial Ford government introduced the Student Choice Initiative policy, which allowed students to opt out of ancillary fees deemed non-essential and which were previously mandatory as part of tuition fees. And this included paying fees to the CFS. In May 2019, the CFS, the Canadian Federation of Students in Ontario, challenged the Students' Choice Initiative in the Divisional Court of Ontario, questioning the ministry's authority to interfere with student fees, which are primarily decided through students' votes. In November 2019, the Divisional Court struck down the Student Choice Initiative, and student fees regained mandatory status in 2020. In December 2019, the government was granted leave to appeal, and in December 2020, 6 groups, including B'nai B'rith, represented by Aaron and his partner David at RELAW, were granted intervener status among numerous other organizations to intervener status in the case, which is, to my understanding, set to go forth in the next few weeks at the Court of Appeal. So the background in terms of why B'nai B'rith, and I'm sure Aaron will get more into this, as to why they felt they wanted intervener status, had to do with the BDS resolution and their belief that, and a previous campaign of encouraging students to opt out of the CFS fees to avoid directly giving money that would be used to support BDS. And on that note, I think Aaron and Ben, Aaron, maybe you can start off by giving a bit more background information.
Yeah, absolutely. And I think that was a great description, Noah, because it's sort of a complicated process. It's sort of, it's difficult to understand exactly what's going on there, especially because it's a really pre-pandemic issue, right? And politics have changed a great deal over the pandemic. So it's hard to understand sort of what's going on there. But and just to just to preempt Benjamin, because I'm very curious to hear his thoughts on generally litigating against student associations, because student associations tend to be the most litigious when it comes to these types of concerns on campus. And I got to tell you, from my experience dealing with this challenge, it's incredible the types of legal resources available to student associations to do legal advocacy. When we were there back in May to deal with this in the divisional court, we were acting as interveners for B'nai B'rith, raising the voices of Jewish students, basically saying, look, Jewish students do not support this student choice initiative because for years, Jewish and pro-Israel students have been mandated to pay certain fees, student fees, that went directly into the hands of student associations that were quite clearly directly opposed to their particular political viewpoints and interests, and fundraising and supporting BDS initiatives on campus. So why should it's one thing for student associations to do whatever it is that they want to do in terms of radical politics on campus. It's quite another for them to require students to pay into their various initiatives and support it. It's almost like compelled speech, which in my view, and according to our Charter of Rights and Freedoms, we shouldn't be compelled to contribute to these types of issues. And I know as a student, that was very troubling. I felt as though my voice was being silenced, and I was paying these student associations to act against my interests. So we went there to the divisional court. The gallery was completely full, which anybody that has experience in these types of appeals, these types of court proceedings, there's maybe like one person sitting in the back because they're in the wrong courtroom. So they managed to fill up the room, and that was a great deal of pressure on the panel. Not to say that influenced them necessarily, but optically it's very helpful. And the legal route, I mean, they had the one of the top law firms, some of the best lawyers in the country doing public interest work, advocating against the government on the basis that they should be paid their fees and students shouldn't be able to opt out. And for the first time in my experience, I witnessed firsthand the resources available to these student associations to harness on their behalf and in support of these types of policies. Now, people can have different views on the government's role in policing or regulating student associations and student funds. And ultimately, that's where the court went on this. They decided that the government had overstepped its authority and its jurisdiction in regulating student fees. But ultimately, we're excited because actually on Tuesday is the day that we're going to be going to the Court of Appeal to argue this matter as interveners on behalf of B'nai B'rith, which is the only organization, as far as I understand, and maybe that's changed with other interveners for the appeal, but certainly at the lower court level, it was the only Jewish organization that managed to get a foothold in there, and thankfully, because it's the only organization that's saying Jewish and pro-Israel students don't want their funds going to these student associations and the radical pro-BDS initiatives. And so students, Jewish, pro-Israel, whatever, should be able to opt out of their student fees and not be forced to support the speech, either expressly or implicitly by virtue of paying these fees. So we're looking forward to being there on Tuesday. And I imagine it will be another showcase of the resources, the deep pockets of student unions and other related organizations that are pro-BDS and in my view, serve to promote interests that go against Jewish and pro-Israel students.
I think, sorry, go on, Noah.
Oh, Ben, I was going to just try to bring you in. So that's, if you've got something to say, that'd be great.
Sure. Well, I'm going to sort of look at the issue of student governing efforts vis-a-vis BDS more broadly. I think the situation that Aaron just described is exactly where legal action is appropriate. And I certainly hope to see this case be successful. I mean, here again, we're not talking about just sort of a policy statement of a student group saying we support BDS. We are seeing actual use of student fees towards this activity, and that's quite different. But stepping back, for the most part, what I see is on the student government level is these BDS resolutions that take a variety of forms. More and more, they're sort of being couched as it's not anti-Semitic. Even some of them don't specifically talk about Israel. They sort of look more broadly at supposed occupations. Whether some people think that's better because Israel's left out of the direct rhetoric, if you will. I personally don't, because anybody who cares about these issues knows exactly what these resolutions are focused on. But what I think is important to know, and at least I get asked a lot, is that the run-of-the-mill student government BDS resolution tends to take the form of accusing Israel of apartheid and war crimes, various other, mainly war crimes, and to talk about the Palestinian plight. These are not things that you can argue with even logically. You can't have a rational conversation if someone is just presenting what are flat out lies and misapplication of legal terms. And I think to some extent, unless you have somebody on the pro BDS side who is really interested in looking, which tends not to be the case, I just don't see dialogues and back and forth about Israel's not an apartheid state, or prove that war crimes happen. Where do you get this? I just don't think that kind of conversation goes anywhere. And while I certainly think that these resolutions are very problematic in that they foment division and anti-Zionism, but also anti-Semitism on, although those two are, I think it's hard to separate the two. They foment all this on campuses. It's important to keep in mind that beyond that, which is very problematic, they don't ever tend to have a practical impact. I see articles in the Jewish media all the time about X school passed BDS and Y school passed BDS. What do these resolutions do? They call upon administrations to, for example, do studies of all the companies that the school is invested in and that are also supposedly complicit in Palestinian human rights violations, and to divest from them. So they call for first this sort of review of all the investments and then to act on it, to actually divest. But time and again, we see that the administrators at worst, if you will, just ignore it and don't follow through on this. The resolution passes. You don't see any studies about what companies they're invested in. You do not see any divestment from companies operating in the disputed territories, Judea and Samaria. At best, though, you have administrators who come out and say very strongly, we do not support BDS. The entire ethos of BDS is antithetical to the values of this school. And we can't stop a student government from passing something like this, but that's the agenda of this small group. That does not and should not reflect again, the morals and values of the school. We firmly reject that. We support our Jewish students, and that's what needs to happen to counteract the fomented anti-Semitism, anti-Zionism these produce. Part of the reason I'm bringing this up is because, while again, I do think it's important to do whatever possible to try to defeat these, to vote against them. As part of that, I strongly encourage Jewish students any Jewish students, I was going to say Jewish students who care about these issues. I hope any Jewish students care about these issues, whether or not they're on this webinar, but you should all be joining student government. If you're not there to vote on these things, we see who else is on student government. If you're not there to vote on them, they're going to pass. And then all we can really do is sit back and complain. Another idea that's recently come up, and I've discussed with a lot of students that has gotten a lot of very positive feedback, is the idea of also putting forward sort of what I would call pro-Jewish resolutions. Resolutions at the student government level that do not have anything to do with Israel necessarily, but proactively affirm Jewish rights. And again, these could be quite simple. This could be all the way from a 3-line resolution recognizing that anti-Semitism is systemic, that it is a problem, that it is real, and that it needs to be condemned, that it is unacceptable on any campus. And something like that also, I should add, it's very hard. This is not controversial, the idea that anti-Semitism exists, that a student governing body should condemn hate. So while issues involving foreign policy in Israel can often be much more controversial, much more difficult to move forward, depending on the makeup of the student government and the student body in general, something like this, again, just adds to this more positive climate for Jewish students, should be significantly easier. We also, we have some other templates for somewhat more controversial resolutions. And I think it's a matter of looking at the individual university and figuring out which makes sense, what there's an appetite for. Some of those involve resolutions against the school or school entities investing, or excuse me, donating to charities that have in one way or another supported terrorism, all the way to agreeing to prohibit student groups or anybody associated with the school from officially hosting events featuring terrorists. I don't think we have time to go into this now, but this idea came up after a situation last fall where the Lawfare project was involved in, where a group at San Francisco State University and then several other universities thereafter attempted to host Layla Khaled, a 2-time plane hijacker and leading member of a foreign terrorist organization. So again, this might be a little bit more controversial, but still, we're looking at things like that where it's unlawful, arguably, but the argument is very compelling that it's unlawful in the first place to host somebody like that. So why wouldn't the student government pass a resolution that essentially affirms we won't do something unlawful? Again, looking at things, proactive measures that Jewish students can take rather than just endlessly responding to BBS.
Thanks for that. And I'm actually on the point that you just made about Layla Khalid and sort of bringing in like radical sort of speakers that are being allowed and sort of welcomed onto campus. It sort of brings us into our next case study and sort of continue the conversation around sort of on campus and with the student associations, because as Aaron mentioned, they seem to be the most litigious on campus and they've clearly got all these funds. So the second one has to do with a human rights complaint that Hasbara Fellowships filed back in 2016 after the student associations of Durham College and the University of Ontario Institute of Technology were excluded from participating in their advertised social justice weeks. And I believe, Aaron, you were also involved in representing Hasbara, if I'm not mistaken, or?
I wish I were, but this was an amazing project and an inspiring one, which I'll.
So pretty much from this, you made the point of that we're letting on all these extreme speakers are being allowed and invited onto campus, such as Layla Khalid. But an organization like Hasbara Fellowships, which we all know is doing great advocacy work on the behalf of Jews and Israel, they were not allowed to participate. So what are your thoughts? It's clear, and this is all student associations, which you made the point that Jews need to get involved in student associations, and absolutely they definitely do. But clearly we've got activists embedded within student associations. So how is it, do you see like rooting that out and sort of getting past that as being sort of like, what route would you suggest there? Maybe start with Ben or Aaron, whoever.
To me, and I'm curious what students say, because this is an area that really interests me. When I was at York and I was a student leader, I felt that there was an absence of support by the legal community. I knew it was there, and I knew that I knew many lawyers and people in the legal world that were passionate about the same issues as me, but I felt like I didn't feel like that was particularly forthcoming. There were some amazing advocates and just some amazing Canadians. An example of that is Justice Morgan, who advocated on behalf of Hasbara. He's now obviously a justice. He was a great lawyer and legal mind, and now he's on the Superior Court doing amazing work on the bench. And I specifically recall in one instance, we were in an administrator's office and he was standing over the desk of the administrator and passionately arguing that the students were being mistreated by the university. And that was such an amazing image for me, because it was, here's a person who is devoting their time and resources, in my view, unnecessarily, but clearly for passion's sake and because they believed in the cause, and helping out these little Jewish students who just needed the support. Later on in years, I felt like that was lacking. And so that's what really, really inspired me to reach out to students and be part of these discussions, and to reach out to students when they need that support. What I'm really curious about, and so just closing off that loop, what I think is so amazing about this initiative, and why I was quite frankly jealous that I couldn't be a part of it back then, because I was just a lowly associate on Bay Street, but I was so inspired by this action because it felt like this perfect merger between students needing help and organizations and lawyers reaching out their hand and saying, we will help you, we want to support you. That connection is not as easy, you know. It's not so easy to make. And when there's an urgency, it's sort of hard to find that resource. So it's so important to be reaching out. And I'm curious if students feel like they're getting that support, and what types of things would be, what type of support would be helpful to them in combating. I know that there's a lot of stuff happening across the country, and I'm sure Benjamin can talk about it around the world, and especially North America. But I'm curious, do students feel like there's that outreach, there's enough outreach, or that there are some gaps that they feel could be filled by the Jewish community and the pro-Israel community more broadly, but also in particular the legal community, and how we could make those connections.
All right, so we're getting some other great questions in the chat box. So I'm going to ask Josh Aziza if he wants to unmute and come on camera for a second. He asked a great question about the administration and the faculty, and you'd like both of your inputs on that. So Josh, if you can unmute yourself.
Thank you very much, Noah. Benjamin and Aaron, you guys have both done a really good job and have partly answered the question, I think, but especially once again in the case of the University of Windsor, you've spoken extensively in general about what students should do and how they're doing here, and how they should pursue their case to administration when there are a lot of anti-Semitic incidents, both from faculty and students in a school. But when the administration, by and large, has a preformed view on these issues, and there really isn't a lot of recourse to them, that they've sort of made their views known, where does one turn, and how does one continue to pursue their case in these instances?
That's $1 million question. I'm going to defer to Benjamin while I.
So I do have some thoughts. I will say that my answer to this, although I'm focusing more on the practical aspects, this is to some extent under the framework of US law, specifically Title VI of the Civil Rights Act of 1964, which Nitzana mentioned earlier. So if there may be key differences with a relevant Canadian law, if there are, Aaron, please chime in and contradict me if need be. But I think what's important here, at least when you're dealing with administrators, is even if you know that they have biases and preformed opinions, is here you at least have to try and to show. I mean, sometimes this is fruitless and it may seem like a waste of time, but you do have to go and have meetings and bring problems to the right people and give them an opportunity to address them effectively in compliance with the law and in compliance with school policies. If they don't, then I tell students all the time, then kind of go up the ladder. Is there someone higher up if you're getting blown off or something? I think it depends on the nature of the response from the specific official who you deal with first. And again, I don't want to give a blanket statement, but if you're just not getting what you think is effective and what you think the rules and the law provide for, then you can try going up the ladder to the next highest person, or even higher than that. I've advised students at times to go directly to the president, the president or the chancellor or the dean, the highest level. And then if it's not something that they can deal with for whatever reason, they will refer the students to whoever is most appropriate. And again, this is something that attorneys or whoever else can be helpful with behind the scenes. It doesn't, when you come to us, for example, for advice, this doesn't mean we're necessarily liaising with the school on behalf of a student. We're here to help in whatever way you think is best and whatever degree of involvement you think would be most helpful. Ultimately, the student is the client. This is something to help them, not to advance our organizational initiatives, as it were. So here at least you do need to generally go through whatever proper channels are. But then if you really are not getting appropriate results, then it maybe is time to pursue legal action. Just as an aside, this isn't quite to your question, and I hope I, to some extent, answered your question. But what I think is also really important is just keeping in mind some more of the practical aspects of how to be dealing with faculty or administrators. One thing I will say that that again, I guess I've said so many times, I kind of see it as a given, but apparently it's not always, is to keep a very careful and thorough paper trail of your interactions with professors. Especially now, a lot of things are dealt with, I guess beforehand, but now with the pandemic, many things are dealt with via email that might be dealt with in person previously. So certainly email, obviously you have the record right there. But I tell students all the time, if you go and meet with an administrator and you bring them a problem and they say we are going to do X, Y, Z, or even we're going to look into it, and then students should be saying, okay, in a nice professional, amiable way, by when do you expect to be able to do this? What happens next if you determine X? Ask as many questions as you, the students, want to understand what not only what is supposed to be happening, but basically what the school is committing itself to doing for you and when it will be done. And then if this is something that's in person, follow up with an email. It says, thank you so much for taking the time to meet with me to discuss X, Y, Z. Just to recap, I really appreciate your commitment to taking X step by Y date, things like that. Who knows, that may put off some administrators, but I don't care. You need to set yourself up and to set them up to be in the best position to actually effectuate what it is that you want. And if the school is not handling it properly, if you later on want to go ahead and pursue some type of legal action, again, I'm looking at this more under US law, then you will be prepared with this full record of here are the efforts I've made. I've done everything right as the student. Here's what the school told me they'd do. Here is what their rules say they need to do. Here's what the law says they need to do. They haven't done it. So and there's more to it than this, but these are issues that we talk with students about all the time, and yeah, they're not always obvious.
Thank you very much
for that question, Josh. And sort of on that point, I just want to, before we get to one more question, and then we're going to actually have to wrap things up as we're running tight for time. But one question sort of building off of Josh's that I just wanted to ask you about was I've had the great experience of being able to work with Josh at Windsor Law and a lot of Jewish things, but an experience that we've been having personally is we've approached the administration, they've been involved and have been engaged, but sort of it seems like things, especially having to do with anti-Semitism, come off as negotiable. And whereas other things, like sort of if you were dealing with anti-Black racism on campus or something else, you would never tell a student that no, what they're feeling isn't that, or how they're suggesting that they deal with it is not the way to do it. But when it comes to anti-Semitism, it all seems negotiable. We've brought up wanting to adopt the Ihra definition of anti-Semitism. They come back that no, we think that that's way too extreme and will hinder free speech and all of that. We want to adopt the IJV definition, which I don't know if you're familiar with, is really a pretty weak definition compared to the Ihra. So it just, students on campus, and this will go into Alyssa Schwartz's question, I think very well, if she wants to come on mic and ask it. But it really seems like our concerns are negotiable, whereas you would never tell another student that sort of way. So I wonder if either of you have a thought on how we could best push through that, because students sometimes feel that, okay, we're at least making some progress. Are we going to be dumb if we don't take what we can get, sort of thing, and not push for what we truly believe we need? If that makes sense. Do either of you have anything to say? Sort of, I guess.
Well, you know what? Yeah, you know what? I'm very familiar with the experience of University of Windsor students, and I have a lot of sympathy for them, not only because I spent some time at University of Windsor, but you know, I have a bit of a different view on Canadian university administrations, and that would be a low view, and that may just be my anti-authoritarian perspective generally. But I've dealt with university administrations, and I've had very difficult times with them, both as a student and a student leader, and also as a lawyer representing student leaders. You know, my personal view is that you have to force the issue. anti-Semitism is bad for business. And the easiest way to deal with it is to brush it off or brush it aside and hope that the semester ends before something major blows up. And so meeting with the administration sometimes can help. And certainly there are some amazing Jewish and pro-Israel administrators and professors and faculty, et cetera, that really raise the voices of Jewish and pro-Israel students. But generally speaking, administrators are bureaucratic fat cats who are more interested in protecting their government funding and maintaining donorship levels than they are about concerns about various cohorts of Jewish and pro-Israel students that are concerned about their treatment. That's unfortunate. And when there's a clash of interests, in my view, it's important that Jewish and pro-Israel students speak up and force the issue. If you're not getting anywhere with the administration, if they don't feel like they're treating your concerns seriously, well, then there are a number of resources, and Benjamin spoke about the types of resources that are available to you, but go public. Tell the Jewish community and the broader community what's happening to Jewish students. It's amazing how much power one student has. You're talking about York University, 50,000 students. University of Windsor is smaller, but still a large school. And so your voice matters. And, not to get, too religious here, but the Rebbe, Lubavitcher Rebbe, explains that every person has a mission. Every person has a voice that can change everything. And so I think that if you're not getting anywhere with the administrators, you really have to force the issue, get out, reach out to the resources that are available to you, and speak out publicly about what you're facing. Go to other like-minded organizations, talk to them, other student groups that are feeling the same way, talk to them, build those coalitions and speak up, form a campaign, talk about the issue that you are facing and other Jewish students are facing, because as student leaders, you're the ones on the front line, and you have a certain sense of responsibility to the rest of your counterparts to speak up.
I'll just add to that. I agree with Aaron that I think much as there are sometimes where administrators will step in and do the right thing, for the most part, the main purpose in going to them is, again, just say that you have done everything you needed to do to put the school on notice of the problems and they have failed to respond such that you could go forward. But I think also he makes an excellent point about speaking out publicly about this. I mean, even contacting journalists, or if you don't feel comfortable doing that or don't know how. I mean, I know that Aaron and his firm deal with press contacts. We do the same. We can help you with that. And I think also if you have a problem already and you could sort of add to the story the lengths you have gone through to try to address that problem properly within the school, I mean, get that out there. That just embarrasses the school more and puts their feet to the flame.
It's so true. And also not doing that you can easily lose credibility, because if you haven't gone through the proper channels, much like in the legal world, if you haven't gone through the proper channels, you're going to lose a lot of credibility, because they're going to say, well, what were you doing? Why don't you have that paperwork? Why didn't you do that legwork? Why are you just simply going to the media with your issues when you're not going to the proper channels? So I agree, that's super.
So
right,
I wanted to just jump in, because we're really running behind. Yeah, thank you. We're running kind of behind schedule. So I did want to thank Aaron and Ben and Noah very much for that stimulating discussion.
Thank you both.
Thank you. And now it is my honor to introduce our last session today, our keynote speaker, the Honorable Irwin Cotler. The Honorable Irwin Cotler is the chair of the Royal Wallenberg Center for Human Rights, emeritus professor of law at McGill University, former Minister of Justice and Attorney General of Canada, and longtime member of Parliament and an international human rights lawyer. A constitutional and comparative law scholar, Professor Cutler is the author of numerous publications and seminal legal articles, and has written upon and intervened in landmark charter of rights cases in the area of free speech, freedom of religion, minority rights, peace law, and war crimes justice. He was elected 2014 Canadian Parliamentary of the Year by his colleagues and in 2015 received the Law Society of Upper Canada's inaugural Human Rights Award. Engaging the Honorable Irwin Cotler in conversation will be none other than Tiphaera Ziner-Cohen, Hasbara Fellow and Chair of the Hasbara YP Committee and a law student at University of Windsor. With no further ado, I introduce Mr. Honorable Irwin Cotler and Tiphaera Ziner-Cohen.
Thank you so much for that intro, Matthew and Professor Cutler. I just want to say what a privilege it is to have you with us today.
My pleasure, and I'm delighted to listen to those who came before me. I thought the presentations were exemplary.
Okay, guys, so that's like some big shoes to fill, you know, like we're off to a good start. So Matthew, I'm grateful that you did it for us because there's no way I could do an adequate bio for the giant that is Irwin Cotler. Professor Cutler, when we were preparing for this discussion, we made a point of saying that the goal here is to really ensure that law students can combat anti-Semitism as soon as they get off of this call. And so I know that there's been a session on the IHRA definition, but as somebody who was a drafter and developer of the IHRA definition and as the leader of Canada's delegation to the International Holocaust Remembrance Alliance, I want to ask a little bit about the trajectory of the IHRA definition. But before we do that, I kind of want to take us back in time a little bit and just to set the frame of our discussion. In many respects, you know, the 1990s laid the groundwork for how we adjudicate hate-based offenses. So as somebody who was intervening counsel on a lot of the hate-based offense cases that went to the Supreme Court, why do you think so many cases pertaining to Section 319 of the Criminal Code went to the Supreme Court in the 1990s? And how has this impacted our understanding of litigating hate-based offenses today?
Okay, a quick historical context. In 1965, the Special Committee on Hate Propaganda, then chaired by Dean Maxwell Cohen of McGill University, where I was a law student at the time, delivered its report to discuss the growth of hate propaganda in Canada and called for legislative initiatives. In 1968, I was then a special assistant to John Turner, the Minister of Justice, and was working closely with the Association of Survivors of Nazi Oppression, basically the Holocaust survivors group of today. And they asked for that legislation. And in 1970, we enacted legislation, now Section 319, et cetera, of the Criminal Code, to the effect that the willful promotion of hatred and contempt against an identifiable group, a group identified by reason of its race, religion, et cetera, in a public place, that became a criminal offense with appropriate defenses in that regard. Now, why did it become an issue in the 80s? Because there was a juxtaposition of two things. At that time, we were engaged on the one hand in bringing Nazi war criminals to justice, but the Holocaust deniers were engaged, and it was not unrelated, to say that there had not been a Holocaust, that it was a hoax. And as Ernst Zundel, the primary Holocaust denier at the time, had put it, that if there were no crimes, that must mean that there could be no criminals. There are no so-called Nazi war criminals to be brought to justice. So there was an intersection of the two issues. A prosecution against Zundel for false news was unsuccessful, but prosecutions under the criminal code offense that I mentioned about the willful promotion of hatred and contempt, 3 cases were joined together for that purpose before the Supreme Court of Canada. There was the Keekster case. Keekster was a Holocaust denier, became a metaphor and message of the movement, Smith and Andrews, and also Taylor case, which dealt with similar provisions from a civil point of view, an administrative law. And the result of those cases was basically to chart the course for the free speech, hate speech jurisprudence in Canada. In a word, the court affirmed freedom of speech as the lifeblood of democracy. But then relying on Section 1 of the Charter, which said that the rights and freedoms guaranteed herein are subject to reasonable limitations prescribed by law as can be demonstrably justified in a free and democratic society, they held that such legislation prohibiting the willful promotion, etc., was legislation that was intended to protect the inherent dignity of the targeted group, to protect the equal dignity of that group. And this wasn't just a speech issue, it was an equality rights issue, to protect the rights of minorities from group vilifying speech. So it was a minority rights issue. It declared that Canada had international treaty obligations to prohibit incitement to hatred, hostility, and discrimination. So it was an international law issue. It was also comparative law. They brought in other jurisdictions to show that there's no such thing really, that all speech is protected speech, even under the First Amendment. For example, under the First Amendment, perjury is not protected speech because of the right to a fair trial. Pornography is not a protected speech because of the right to the consumer. False advertising is not protected, etc., etc. So the court held that, in fact, such hate propaganda was not protected speech. I've given you a very quick and overly abbreviated summary, but it was a trilogy of the most important cases in hate speech jurisprudence. But as one wag said about Canada, cancelled for lack of interest. So none of our hate speech jurisprudence is known as it should be internationally, because it serves as an important principle and precedent for what could be acted upon in other jurisdictions.
And I'm just hoping that all the first and second year law students on this call who have any upcoming constitutional exams are listening extra closely to that answer. So, and so Professor Cutler, on that note, you know,
I'll just may say, Tiphaera, just a quick, not as a promo, but if I was unclear or confused or anything, I wrote a piece. It was in the Supreme Court Law Review on hate speech, equality, and harm in 2005. The basic principles and precedents remain the same.
Perfect. Okay, so any first and second year law students, there's your homework. There you go. So Professor Cutler, on that note, so that was in the 90s, and you know, so now we're progressing. One of the things that I've noticed is that our criminal code does not actually provide a definition for or an offense pertaining directly to a hate crime. We see hate crimes being applied as an aggravating factor at sentencing. So while we, you know, in many respects have these principles that pertain to hate propaganda, do you think that having this definitional problem is impactability to pursue justice when it comes to instances of hate crimes, not just with anti-Semitism, but also more broadly?
Yeah, I don't think that the definitional thing is as problematic as it might appear to be at first blush. Let's face it, criminalizing the willful promotion of hatred and contempt in a public place, targeting identifiable groups, is a hate crime. There are other specific provisions that if you target religious institutions, that also would be a hate crime. And of course, if you can demonstrate that the crime was motivated by hate or bias, then you not only can have an enhanced sentence, you can prosecute for that purpose. So it does, we could have a more maybe delineated definitions, but I also want to say that Canada is a state party to international treaties, such as a treaty on cybercrime, which also defines, you know, certain hate crimes. So if you look, you can find, and I think we do have the framework. What is needed always is the political will to act and to initiate the prosecution for that purpose.
Absolutely. So, okay, so my follow-up was going to be, you know, whether you think the provisions that are currently in force are sufficient. So I'm sensing sort of ish. How do you respond to that?
Well, I would just say, number one, I think we should realize we do have provisions. We do define what are hate crimes. We can be more specific, but we need to be even more effective with what we already have at the same time as we move to make it more specific and clear.
100%. I completely agree with you. So okay. So everyone that's on this call right now, we have a I would say nearly once in a lifetime opportunity to speak with one of the drafters of the IHRA definition of anti-Semitism. So we're gonna switch the game a little bit and talk about the IHRA definition a little bit. I know we've already touched on it, but we're really gonna look at the development of the definition. So Professor Cutler, you've been involved in the IHRA in developing this definition from the get-go, working with individuals like Holocaust hero Elie Wiesel and former Swedish Deputy Prime Minister Per Ahlmark. And so, this began in the late 1990s. And so I'd love to get your take on what the initial impetus was behind the need to start working on having a comprehensive definition.
Well, the original impetus came from the Stockholm Conference on the Holocaust held in January 2000 in Sweden, which issued the Stockholm Declaration, which spoke of the unprecedented horrors of the Holocaust and anti-Semitism, of course, in its relation to the fact because Jews were murdered in the Holocaust because of anti-Semitism. But regrettably, anti-Semitism did not die in the Holocaust. And as I said then in speaking in the year 2000 in Stockholm, that it remains the bloody canary in the mineshaft of global evil today. That was in the year 2000. And this was similarly felt, as you mentioned, by the then Deputy Prime Minister of Sweden, Per Ahlmark, by Nobel Peace Laureate Elie Wiesel. And we started to work on identifying the metrics for the new anti-Semitism. We had metrics for the old anti-Semitism. The Jews have too much power, do they control the media, etc. But there were no real metrics for the new anti-Semitism. Then came the Durban Conference in 2001, a world conference against racism, which turned into a conference of racism against Israel and the Jewish people, where the first international conference on human rights in the 21st century, just as it was the first world conference against racism in the 21st, then turned into a conference singling out Israel as the meta human rights violator of our time. And a conference that was being held in South Africa to commemorate the dismantling of South Africa as an apartheid state became a conference that called for the dismantling of Israel as an apartheid state. And I can still see the chants and the marching in the streets. I was there in Durban. I was a member of the Canadian delegation. And this festival of hate has imprinted itself not only on my memory, but on my psyche. And all those who were there remember it. And remember the chanting that the struggle against apartheid in the 20th century requires a dismantling of South Africa as an apartheid state, and the struggle against apartheid in the 21st century requires a dismantling of Israel as an apartheid state. And because, as we know, that apartheid is defined in international law as a crime against humanity, what they were effectively saying and said that if Israel is an apartheid state, therefore it's a crime against humanity. If it's a crime against humanity, it has no right to be. And if that were not enough, then Israel is also held out to be a Nazi state. Not only does it have no right to be, but we have in effect an obligation to make sure that it has no right to be. So under the laundering of anti-Semitism, under universal public values, under protective authority of international law and the like, came all the manifestos growing out of Durban that then found expression in the BDS movement in Israel as an apartheid state, etc. Just one thing that I'll mention that came out of the Durban Conference, but I can mention many, except that this occurred within 3 months of the Durban Conference, and that is the contracting parties to the Geneva Convention. The Geneva Convention being the framework for international humanitarian law, put one state in the docket for the first time. That state was Israel, not Syria, not Russia, not any of the other major human rights violators of our time. And since the Durban Conference, the contracting parties to the Geneva Convention have met twice more. And in each instance, Israel was put into the docket of the accused. So in the 3 occasions in which any state in the international community could have been singled out as a violator of the Geneva Convention's international humanitarian, only Israel was singled out. And the momentum, and I'm using just one of many examples, began regrettably in the Festival of Hate of Durban.
And I just want to say, it's definitely not on the same level, but I can tell you when you came back from the Durban Conference and gave a speech to, I forget which communal organization it was, that was really, the transformational moment for my parents, and the way that they've raised my brothers and I was really hearing what you had to say after Durban. And so I think I'm really trying I want everyone to really understand how severe the events that Durban really were, in terms of how it completely reshaped and reframed the way that Israel and the Jewish people are understood. And Professor Cutler, I have a quote from which, by the way, another plug. If you haven't read Anti-Semitism, an Assault on Human Rights by Professor Cutler from 2006, there's some more homework for you, because it is such a brilliant article and really breaks down all of the forms of anti-Semitism that we are dealing with right now. But in that piece, Professor Cutler, you wrote that classical anti-Semitism is the discrimination against, denial of, or assault upon the rights of Jews to live as equal members of whatever society they inhabit. The new anti-Semitism involves the discrimination against, denial of, or assault upon the right of the Jewish people to live as an equal member of the family of nations, with Israel as the targeted collective Jew among the nations. So I would just love to get more of your thoughts in terms of how this conference set up the social climate, the current social climate that we're dealing with. And I can tell you, for students on campus, this is a really big issue of framing Israel as being in opposition to the work that is anti-racism. And so I would just love your thoughts just in terms of how this conference really created that social climate, and even, on the notion of intersectionality and the impact that it's had on how we understand that. So.
Yeah, the irony is that when the first public announcement for the Durban Conference, the World Conference Against Racism, was made in 1997, I and others were very excited about this, because we felt this was going to be the first conference against racism in the 21st century, the first conference to commemorate human rights in the 21st century. But then, as I said, that would just to be a conference against racism turned into a conference of racism against Israel and the Jews. It effectively turned the whole anti-racism movement on its head. And in fact, within weeks of the conference, at the Durban Conference, there was a resolution at the University of Michigan that called for the recognition of a two-state solution if Israel were to become a democratic state. So that was bad enough already, because that resolution was defeated to be replaced by, and this was the followed from the Durban Conference, a resolution to call for the dismantling of Israel as an apartheid state, again, within weeks of the Durban Conference. So if we think back to the beginning of the 21st century, then human rights had emerged at the time as the new secular religion of our time. And I, as someone and others who were involved both in the teaching of human rights and practicing of human rights, celebrated the fact that human rights had emerged as the new secular religion of our time. But what happened was that the Durban Conference singled out Israel as the new, not only the major human rights violator of our time, but almost as the new antichrist of our time, at a time when human rights had emerged as a new secular religion. Now, don't get me wrong, I'm not saying that Israel somehow has to be above the law, or that the Jewish people and Israel deserve any special privilege or preference because of the Holocaust or other horrors of Jewish history. Not at all. What I'm saying is, no one is seeking to say that Israel should be above the law, but that Israel has the right, like any other state, to equality before the law. Not that human rights should be applied to Israel, they should, but they have to be applied equally to everyone else. Not that Israel should not respect human rights, she must, but the rights of Israel deserve equal respect. And so this is really about issues of equality rights, human rights, and what's at stake here really is the integrity of the human rights movement itself.
couldn't agree more. And you know, not to get too sidetracked, but when you look at how the human rights order was developed and who it was developed by and how it came out of the events of the Second World War, I think it makes it just that much more disheartening to see it turned on its head in this manner. So okay, so we have Durban, and we know that this really changes the atmosphere that we're dealing with. And you know, there's a lot of movement occurring in the aftermath of Durban around the development of the IHRA definition. So speeding forward a little bit, in 2008, you, Professor Cotler, alongside British MP, now Lord John Mann, established the Interparliamentary Coalition to combat anti-Semitism. How did the introduction of this cross-border alliance assist not only in the development of the definition and in terms of the international consensus around it, but also in terms of how to actually combat anti-Semitism?
Okay, I want to be conscious of time, but I just want to take it back just a step for a moment, because when we speak of IHRA, we see it as the most authoritative, comprehensive, international consensus definition that we have. But what is ignored by those who either have an ahistorical approach, who are uninformed or misinforming, is that the IHRA working definition of anti was adopted after a sustained democratic process involving intergovernmental bodies, governmental bodies, parliamentary bodies, civil society leaders, academics, experts, and the like. So when we returned to Durban, after Durban to Stockholm in 2002, we started to chart the course of identifying the metrics. As Minister of Justice in 2005, I worked with the European Center for the Monitoring of Racism and Xenophobia. They set then what were the benchmarks that were to come IHRA. In 2008, as you mentioned, with John Mann, we launched the Interparliamentary Coalition to Combat Anti-Semitism. That adopted in London in 2009, and then in Ottawa, the Ottawa Parliamentary Protocol in 2010, the declarations that effectively embodied the pathways that became the IHRA definition. And this culminated, if you will, in 2015. And I think for us as Canadians, it's important to appreciate this, because the pathway that I'm describing shows the role of the Canadian role of Canada as a country in being an architect of the IHRA definition. And there was a very significant resolution adopted in February 2015, unanimously by all parties in the Canadian Parliament, which had three parts briefly, which said as follows: alarmed at the global escalation in anti-Semitism. That was in 2015. It's gotten much worse since then. Second, called upon the Canadian government to make the combating of anti-Semitism a priority in both our domestic and foreign policy. And then number three said, criticizing Israel is not anti-Semitic and saying so is wrong, but singling Israel out for selective opprobrium and indictment, denying Israel's right to exist, let alone calling for its destruction, is hateful and discriminatory and anti-Semitic, and not saying so is dishonest. That was unanimously adopted. That was a year before the IHRA definition, the working definition, was adopted by IHRA as a whole.
So really what we're trying to show here, Professor Cotler, is number one, and I want to get your feedback on this. Number one, the IHRA definition was developed over a 15-year period with international consensus, both from governmental and non-governmental agencies. And Canada was a leader in the development of this definition. And I just want to point out for those on the call that it was Professor Cotler in one of his last acts before leaving office as a member of parliament to bring that motion to the floor. So I want us all to really take a moment to acknowledge the work that Professor Cotler did in jazz hands, everyone, in making this a part of Canada's work. And so I really want your feedback in terms of the consensus. I'm trying to bring home the point for the students on the call, just how much consensus there is around this definition and why there's such an impetus to get it adopted as we continue moving forward.
Yeah, the important part is the parliamentary antecedents as a parliament, as trustees of the people, giving expression to, in effect, what the people of Canada were calling for, and not just the people of Canada. We had parliamentarians from over 50 countries that were at the Ottawa Conference in 2010. So to speak as if the Ihra definition was suddenly created out of whole cloth, is ahistorical and misinforming, and does not appreciate the democratic, representative, and inclusive character that led to the adoption of the Ihra definition. And then when I hear also that the Ihra definition, silences speech, this too is turning the Ihra definition on its head, because the Ihra definition was intended to be protective of speech, protective of the speech, for example, of Jewish students on campus or their supporters, so that they will not have their speech silenced, or they will not be bullied, or they will not be disenfranchised. The Ihra definition is there to enfranchise their equal rights as students on campus, to give protection to their freedom of speech, to give academics protection for their academic freedom. And it protects those who are critical of Israel. It is protective of those who seek to affirm Palestinian rights. You can affirm Palestinian rights. You can be critical of Israel. You can be critical of Israeli policies and practice. What you can't do is slide inexorably into the denial of Israel's legitimacy, or the denial of Israel's right, the Jewish people's right to self-determination, which, as Martin Luther King said, is a right which we call for all peoples of the world, including African nations, and belongs also to the Jewish people. So those who are seeking to undermine the Ihra definition, either do not have an appreciation of the representative democratic character of that definition, but that it is protective of the very things that they say they are concerned about. And so I sometimes wonder if that's what they really are concerned about, or they simply don't want the Jewish people to have their right to self-determination protected. They simply may not want Jewish students to have their right to free speech protected, and so on.
I could not agree more. And I literally have goosebumps listening to this, because Noah spoke on it, and so did Josh, but for the students at Windsor Law, there has been so much pushback in terms of, we will not be taking action on anti-Semitism until a definition is adopted, and the IHRA definition restricts speech, to which we've responded, it actually provides a parameter so that you can criticize Israel without falling into anti-Semitic rhetoric. So just briefly, I know we've basically already touched on how you would respond to the critics, but in a word or a sentence, how would you respond to the critics so that I can take this to my administration after this call?
Well, the point is, if you can't identify it, anti-Semitism, and if you can't define it, then you're not able to combat it, in this as in everything else. And so if we want to combat anti-Semitism, which is the oldest, most enduring, most toxic, most lethal of hatreds, which is an assault on our common humanity, and if we care about our common humanity, and I see the struggle against anti-Semitism as being part of the larger struggle for human rights and human dignity in our time, and I suspect that students, care about human rights, care about human dignity, therefore they should care about utilizing the Ihra definition. It's a non-binding definition. It is there as a resource. It is there as an educational resource. It is there as providing us a foundational framework for being able to understand, to recognize, to monitor, and then to combat this most lethal of hatreds.
I couldn't agree more. And so on that note, Professor Cutler, I want to ask you, let's put this into action. What can students like myself do on our own respective campuses, either in relation to combating anti-Semitism or in getting the IHRA definition adopted? And more generally, what is, the action plan? Because I recall us discussing, you have an action plan. And so we want to be a part of it. What can we do to help, and how do we get started?
Okay, I'll do it in terms of one-liners for reasons of time, and also because the students are an informed audience, so they need no elaboration. The first thing is, as Ahmed Shahid, the UN Special Rapporteur on Freedom of Religion and Belief, put it in his landmark report on anti-Semitism, the first ever comprehensive report by a senior UN official, and he put it that we should be analyzing and combating anti-Semitism through a human rights lens. And that has been the burden of what I've been saying up to now, because anti-Semitism, as I said, is a fundamental assault on human rights, toxic to democracies, as Ahmed Shahid put it, and an assault on our common humanity. The second thing is we need to enhance the adoption and the importance of the Ihra definition, which, as I said, is the most authoritative, comprehensive, representative international definition we have. And therefore, we have to enhance the number of not only governments and parliaments, but universities and student bodies. And we can take a leaf out of England, where the leading universities there, Oxford, Cambridge, and the like, have all adopted the Ihra definition. Number three, we need at this point to appreciate also, when we make the case within the campus culture or otherwise, of the important, as I said, parliamentary antecedents for the Ihra definition that underpin the Ihra definition, as well as the intergovernmental bodies that I mentioned, the academic experts. And let us not forget that Ihra was International Holocaust Remembrance Alliance itself, as an institution, was established as a result of the Stockholm Conference in 2000, which then led to one of the actions being the adoption of the working definition on anti-Semitism. There is an excellent European handbook on Ihra that was just produced by the European Commission. It came out towards the end of 2020. This can be a model as well for students to use. And I would recommend that students consider producing a Canadian version of the European handbook, because, as I said, Canada played such a pivotal role in the pathway to the adoption of the Ihra definition. It would be useful to trace that history. Number five, we need to combat Holocaust denial and distortion, which is the cutting edge of old and new anti-Semitism. And here too, on January 19th, 2021, the Ihra produced a handbook on combating Holocaust denial and distortion. Number six, we need to combat not only anti-Semitic speech and hate crimes, as we've discussed, but in particular, the explosion of hate and anti-Semitic speech on the internet. I mean, that is really emerging as a clear and present danger. And during the pandemic, we saw all the old ancient classical tropes of anti-Semitism now being revisited, where Jews, the Jewish people in Israel, were held to be responsible for the manufacture of the COVID-19 virus, for the spread of that virus, and were said to be profiting from that virus. So all the anti-Semitic tropes as part of the COVID pandemic. Number seven, we need to call upon political leaders, as Dr. Shahid put it, to have a zero tolerance policy for anti-Semitic discourse and discrimination in their respective political parties and in the public arena, and also to refrain from weaponizing anti-Semitism for political purposes, because that undermines both the struggle against anti-Semitism, it undermines also the Ihra definition. Conservatives should call out anti-Semitism within the conservative movement, liberals should call it out within the liberals, etc., etc. We all have to be accountable. Number eight, we need to prepare a national action plan to combat anti-Semitism. Ira has asked us to do this as part of the road to Malmö, Sweden, which is going to be holding a conference in October to commemorate the 20th anniversary of the Stockholm Declaration. It's a year later because of the pandemic. I think students can make an important contribution to what such a national action plan could be. There should be specific and express reference to anti-Semitism in the campus culture and how that needs to be combated. And I'd like to just take a page out of the Soviet Jewry movement, because, you know, we patented what is today called intersectionality. Intersectionality has turned oppressor and oppressed on its head. But if you go back to the Soviet Jewry movement, we had women for Soviet Jewry, students for Soviet Jewry, scientists for Soviet Jewry, parliamentarians for Soviet Jewry, artists for Soviet Jewry. In other words, a critical mass of advocacy for Soviet Jewry, for human rights in the former Soviet Union. We need this same intersectional movement with respect to the combating of anti-Semitism. What we need, in a word, is a global constituency of conscience, because anti-Semitism cannot be fought, let alone be won by Jews acting alone. It can only be won if we create a global constituency of conscience. And as we've always learned in these things, that while it may begin with Jews, it doesn't end with Jews. So we all have a common interest in this combating of anti-Semitism. And finally, I also want to make a word about anti-Semitism in the international arena, in international institutions, because what we've been witnessing has been, and I reference it, the laundering of anti-Semitism under the protective cover of the United Nations. For example, where every year we have 20 resolutions in the UN General Assembly singling out one member state of the international, which happens to be Israel, and some 5 or 6 resolutions against the rest of the international community combined, giving them exculpatory immunity and thereby a danger, clear and present danger to the protection of human rights. The second thing is the laundering of anti-Semitism under the authority of international law. I gave just examples regarding to the Geneva Convention, but it would hold otherwise. The laundering of anti-Semitism under the culture of human rights, where the UN Council on Human Rights, whose mandate is the promotion and protection of human rights at every meeting of that UN Human Rights Council, and I've appeared before on a number of occasions, every meeting begins with a targeted Agenda 7 item that targets one state in the international community, human rights violations by Israel in the occupied Palestinian territory, an Alice in Wonderland situation where the conviction and sentence are passed even before the hearing begins. And finally, the laundering of anti-Semitism under the struggle against racism. Let's face it, the worst thing you can say about anybody in the world today is to call them a racist. The very word supplies the indictment. And if any further proof is required, then what you do is you refer to Israel as an apartheid state, the Jews as being apologists and white supremacists defending this apartheid state. And that takes you down the road to the notion of Israel as a Nazi state, and all this as prologue and justification for the dismantling of the only Jewish state, and therefore Israel as a targeted collective Jew among the nations. And so I remember so well the words of the former Secretary General Kofi Annan, as he would repeat them to me again and again, that a United Nations that does not put the struggle against anti-Semitism at the forefront of its agenda is a United Nations that betrays its past and forfeits its future. And we have to remind those who abuse the United Nations for the purposes of delegitimization that the time has come to return to its original founding ideals, the most foundational principle of which is equality for all states before the law, big and small.
Hear, hear. Okay, so we have our homework. That was those 10 steps. I think there's so much for us that we, as everybody on this call, no matter where we're at in our lives, I think that there's actionable things that we can all be doing literally as soon as we get off the call. So 3 pieces of homework for the students, and I guess this is everyone else's homework as well. I do want to bring in a couple of students to ask some questions, if that's okay with you, Professor Cutler.
With pleasure.
Sadie, if you want to unmute and come on, I think you have a great question in the chat, and I'd love to get Professor Cutler's take on it as well. So if you're still here and want to come on, there you are. Hey.
Hi. Yeah, so I'm wondering, because you mentioned a couple of things, but you also just mentioned the UN, and I'm just interested in what your opinion is on how students should or shouldn't be concerned about the ICC investigation into Israel based upon the Palestinian membership to the ICC, and how that will potentially negatively impact efforts to encourage universities or nation states to adopt the Ihra definition of anti-Semitism, or generally to take action on issues of anti-Semitism?
Okay, I'm glad you asked that question. Let me begin by saying that I don't approach the ICC by saying it's anti-Semitic. I think that's not a good way to address or redress the issues we have. I'll also preface my remarks by saying that I was one of those who was very much involved in the founding of the International Criminal Court as a member of Parliament in the year 2000. I was one of four who tabled and then had enacted the legislation domesticating in Canada the Rome Statute and giving Canada universal jurisdiction in that regard. 2002, I chaired the first ever assembly of parliamentarians for an international criminal court. I say this because I think that Canada has had a long involvement in the ICC, because we saw the ICC as a court of last resort for the pursuit of international justice. Now, fast forward to 2018, and I'll tell you why, and this relates to the ICC. In 2018, I was part of an independent panel of legal experts established by the Organization of American States to look into whether there are reasonable grounds to believe that crimes against humanity are being committed in Venezuela. We reported that there were 7 major crimes against humanity being committed in Venezuela, which included thousands of extrajudicial executions, 12,000 cases of arbitrary detention, some of the most egregious cases of torture, rape in detention, and perhaps the worst of all, state-orchestrated humanitarian suffering, a dramatic increase in maternal mortality, child mortality, and the like. Now, 4 months after we produced our report in May 2018, 7 states, 7 sovereign states, of which Canada was one. In fact, Canada led the other states, which included France, Germany, Peru, Paraguay, led 7 states in making the first ever, and to date, the only collective referral to the International Criminal Court of a state party, Venezuela, for these crimes against humanity. Our report was followed by UN investigative reports, which affirmed our findings. And then at the beginning of December 2020, a report by Jared Genzer, the special advisor on the responsibility to protect for the Organization of American States, issued a landmark report that not only reaffirmed what we said, but in fact criticized the special prosecutor, Fatou Bensouda, for the fact that she did not open an investigation against Venezuela, even though Venezuela was a state party, and even though these crimes against humanity were referred to the ICC by 7 states. Now, contrast that with Israel, where the special prosecutor has opened an investigation, even though Israel is not a state party to the ICC, and Palestine is not yet a state, though many of us, like myself, have argued in favor of a Palestinian state, but it is not yet a state. And so what the special prosecutor did was to turn international law and the ICC statute on its head, because if Palestine is not a state, it cannot confer jurisdiction to the ICC to open any investigation. But what the special prosecutor did, she imputed to Palestine as if she was a state, and thereby, as I said, turned law and evidence on its head. I think what we need to do is contrast how the special prosecutor acted in the manner of Venezuela, where the evidence was compelling, where a reference was made by state parties, where Venezuela was a state party and didn't open an investigation, and did open an investigation, where, as I said, Israel was not a state party, et cetera, et cetera. I think that's the way to argue it, and not to argue it in terms of anti-Semitism, because you lose people right away, because if they feel you're weaponizing anti-Semitism. The case is compelling enough on the merits, and the way it should be made is, if you care about the International Criminal Court, if you care about the pursuit of international justice, if you care about equality before the law, therefore, the special prosecutor's opening of an investigation is a breach of the foundational principles of the ICC. Now, the issue is not over yet because there are 3 conditions of admissibility, and with this I close. Even after she has opened an investigation, there are 3 conditions of admissibility. One is the gravity of the offense, and as all the travaux préparatoires, everything says, there's a high threshold for the gravity of. Second, and the major thing is the principle of complementarity. As I said, the ICC is a court of last resort. It's not supposed to substitute its decision-making where there is an independent judicial system, etc. And if nothing else, Israel has one of the most widely respected independent judiciaries and widely respected Supreme Courts in the world. And therefore, there's no place for an ICC jurisdiction. And the last condition of admissibility is in the interest of justice. It is clearly not in the interest of justice to pursue this investigation, let alone prosecute it. Sorry to take a little more time than I wanted to, but I think this is a very important question that you asked, and I think there are very important answers that can be given. Let's not dismiss it on grounds of anti-Semitism. That's too easy to make the case that way, and it looks like it's weaponizing anti-Semitism. There's a strong case on the merits with respect to international justice and the Rome Statute.
Thank you so much.
Thank you, Sadie. That was a great question. Thank you, Professor Cutler. We're going to take 2 more questions. So the first is from Amanda. I'm not sure if she's still here, or there she is, Amanda. If you want to come on live and unmute yourself. And it was a great question in the chat, so I'd love to get it up here as well.
Sure, thank you. And thank you for Professor Cutler. I just have a quick question. I want to take it back to what you said at the beginning of your talk, when you were talking about section 318 and 319 of the Criminal Code. And you said that we need to be more specific when it comes to hate-based crimes and seeing charges laid. And so I'm just wondering how we as community advocates and people working in sort of this area, how can we, obviously I can't bring charges, how do I, as a community advocate, help ensure that the police have sufficient information and education, motivation to gather appropriate evidence, that appropriate charges are laid, there's political will to prosecute things as hate-based crimes, rather than going for the, easier to prove or support lower charges that are often the case. So, I really believe it's important to prosecute under those sections where applicable and possible. So how can we, what can we do to help with that process?
Well, first of all, I think we need dedicated, hate crimes units in our law enforcement frameworks, because unless you have dedicated hate crimes units, you will not have people who will be trained with respect to being able to recognize and thereby lead to the prosecution of a hate crime. And I say the same thing in terms of the training of civil servants in the Department of Justice and the like as to what constitutes a hate crime. The second thing is the Ihra definition is precisely that kind of educational resource for law enforcement officials, for civil servants, for Department of Justice officials, etc., because it identifies really the metrics that will allow law enforcement officials to be able to recognize a hate crime and thereby be able to move to prosecute a hate crime. And so I think and in England, they've done that. They've set up training in the United Kingdom, and I want to commend John Mann for this. Training of law enforcement officials, training of members of the judiciary, training of civil servants, training of the Department of Justice in the metrics of the Ihra definition so that they can better identify, recognize, monitor, and then combat and prosecute hate crimes.
Thank you.
Great question, Amanda, and thank you again, Professor Cutler. I did get a comment just to point out that Fatou Bensouda, the prosecutor from the ICC, is from Gambia, who's also not a member state. So that's also just an interesting little point to add in, but neither here nor there. David, I know you had a question about Ryerson and the IHRA definition. I don't know if you're still here or if you want to to come on and ask it. Otherwise, I'm happy to. David. Okay, I'm not sure if David. Oh, there it's coming. There we go. Oh, nice background, David.
Here we go. Hi.
Hi there.
Very frustrated with my
Very
own
inspirational background, I got to tell you.
There we go. On purpose. So very frustrated with my own faculty association, very difficult to battle it as a single voice. They rejected the Ihra definition at Ryerson University in Toronto. Just by chance, they just started a new law school as well. And nothing that we can do about it in terms of pointing out that their reasoning for rejection is exactly what you said, is that turning it upside down, turning it on its head, saying that it restricts free speech, academic free speech, and trying to get the administration to battle that is an impossibility. It's just replete, the entire faculty association is replete with people who are biased against Israel. It's very frustrating and scary for the students. What can we do? I think you've outlined some things that we can do, but I just wanted it out there to say that, you know, in Toronto, Ryerson University, here's an example where Jewish students are having trouble being on campus feeling safe.
Yeah, I'm not sure if, you know, the professoriate is biased or otherwise uninformed, which can lead to bias in the sense it becomes an uninformed bias. What I've sensed is that most people either have never heard of the Ihra definition or can't tell you what the Ihra definition states, can't identify, you know, the metrics or benchmarks of that Ihra definition, and have no idea that this was, as I sought to share with you, a definition in which Canada played a distinguishable role in its adoption, and it was adopted in a very democratic process over time, as I sought to describe. I think it's going to take some work in the trenches, and, you know, as a former law professor myself, I've seen, you know, decisions reversed when they were initially made without the information at the disposal of the faculty who made the decision. And I think if it's a matter of education. In my action plan, I forgot to maybe emphasize enough the importance of education. And we have to educate people about the Ihra definition. That's why we have, as I said, we have to be very cautious about not weaponizing that definition, because if we use it for purposes for which it was not intended, it will undermine the definition. If we weaponize it in ideological grounds, where the right uses it against the left against the, etc., it won't be effective. Or if we say the ICC is anti-Semitic, etc., I think we have to really use it for where it matters. And at Ryerson, you have a colleague of mine, who was a parliamentary colleague of mine. I believe he's there now as a distinguished professor, and Mario Silva. I mention him because Mario Silva headed up the Canadian delegation to Ihra. And not only did he head up the Canadian delegation to Ihra, he was there when the Ihra definition was being adopted. And so Mario Silva could be a very important resource for you, because he was yet another example of a Canadian present at the creation. And he is somebody who was part of our Canadian parliamentary group to combat anti-Semitism. He played a central role in that 2010 conference that I mentioned, the adoption of the Ottawa Parliamentary Protocol. So he comes with the historical appreciation, and I think he could be a very effective ally. And I'm happy to assist wherever I can as well.
Appreciate that very much.
Amazing. So thank you for that question, David. I can tell you that from the student's perspective, dealing with this is equally as frustrating. So, and I can't imagine being on the faculty side of things. I think that would be even more annoying, for lack of a better word. So the last question, unless anybody has anything to ask, is actually from my esteemed mother, who will not be on screen, but has asked me to ask on her behalf, whether, Professor Cotler, whether you think that Canada's position in respect to Israel at the UN has shifted, and whether that'll have any sort of impact on I don't know, either our relationship between our two countries, or also just in terms of giving credence to some of what goes on at the United Nations in terms of targeting Israel?
Well, first, I want to wish your mother well. I gather that she, has COVID, and your parents also. I wish them both a refuah shlema. And that's the first and foremost thing. The second thing is, I know where that's coming from because I've heard it before. Canada's position has not really changed. In other words, what happened was that in 2000, there were, let's say, 17 or 18 resolutions at the UN General Assembly that were critical of Israel, or condemnatory of Israel. Canada voted no on 17 of the 18. They voted yes on one of them. They voted yes on the one that about the Palestinians having a right to self-determination. And I guess that those who voted, and I had the discussion with this with the Prime Minister, I said people didn't read the resolution in its fullest extent, because if they went into the weeds, they would have seen that it wasn't just about the Palestinian right to self-determination, which I would have concurred in voting in favor. But then I saw some pieces which said, oh, the Canadian government is anti-Semitic because it voted yes on that one resolution. That's problematic, and that's what leads us into the weaponizing of anti-Semitism adversely, because we forget that on 17 of the 18 resolutions, Canada voted no, that its record was better than any other country in the world except United States, that our European allies, Germany, France, the UK, etc., voted in favor of a majority of those resolutions. So, Canada was distinguished by the fact that it opposed 17 of the 18 resolutions. So I don't see that as a shift. I think Canada's position at the United Nations has been consistent, has been principled, and has been effective. And what we have to guard against, as I say, the singling out of the one resolution, which, yes, they should have voted no on that one too, but their reasons for doing so were because they believed it to be a resolution only on Palestinian self-determination. And so we should not disregard the overall voting record. We should look at it comparatively and see that Canada's record was better than any other country in the international community, save for that of the United States. And even in the resolution in which Canada did vote yes, they did also enter cautionary notes at the time that they did so. And I just want to add as a final word, we've got a great ambassador at the UN now, in Bob Ray. Bob Ray is a staunch supporter of the Ihra Definition, understands the Ihra Definition, is able to mobilize support for it effectively, and we should look to him as being someone who can bring yet another informed Canadian voice to what is, after all, at the end of the day, something in which Canada had a distinguishable role in bringing about the Ihra Definition.
I think that's a great answer. I mean, not that I'm the arbiter of these things, but I think it's a great answer. And I also, I just want to point out, Professor Cutler, you've talked about all of these really influential Canadians who are really involved and have been involved in the development of this definition and who support it. And I want to thank you for leading the charge on this and for really being such an inspiration to so many of us on this call. I don't even have the words to say thank you for taking the time to be here and to share all of this with us. And thank you so much. And thank you for the refuah shlema for my parents. I will definitely pass it on as well. And she'll be so happy that she got a call out in front of everyone, as we know. But really, I want to thank you so much for all of the work that you have done, that you continue to do, and for being with us to share this work with us. We appreciate it so much. And thank you really so much for all of this.
Well, I want to thank the Hasbara Fellowship. I want to thank the students. I always use that expression, Mikom Lamdai Hiskalti. I've learned from everyone with whom I've been encountering with. And I have to say that I'm the beneficiary of this encounter with the students. The questions allowed me to even revisit my own thinking on this. And I want to say that law students have a special singular role to play, because you are the ones that are not only in the trenches, but you have the understanding of the importance of facts, of evidence, of law. You appreciate what the struggle for human rights is all about. And as I say, for me, the combating of anti-Semitism is part of, but a very important part of that larger struggle for human rights and human dignity in our time. And the Ihra definition is a central fulcrum in that struggle. And I look forward to continuing to work together with all of you in common cause.
Thank you so much. I just claps for Professor Cotler. That was, wow. Thank you so much, Professor. Really, thank you. And I'm just going to pass it off to Matthew now.
Yes, thank you. And thank you very much. Today has been an incredible afternoon of high-level speakers and thoughtful conversation with practical takeaways, not only for law students and college and university students, but for those in high school and in the general community as well. Thank you again to Nitzana Darshan-Lerner, Arsen Ostrovsky, Isabel Hazan, Aaron Rosenberg, Benjamin Ryberg, Noah Lewis, and the Honorable Irwin Cotler and Tiphaera Ziner-Cohen. I just wanted to say, and I hearken back to what Aaron Rosenberg said, if one of the takeaways should be today that if you're a law student or a university student or a high school student, and you're encountering an issue with anti-Semitism on campus or at the school, there are resources for you. We are here for you. You're not alone, and there is a solution to every problem. And that message goes out to not only the students, but parents, grandparents, and anyone who cares about or has a student in their life. Before we say goodbye, I'd like to turn things back over to Daniel Cohen, our Executive Director.
Matthew, thank you so much. I just want to wholeheartedly echo Matthew's sentiments for all those students out there and for the parents and anyone else that are here. If you have come across anti-Semitic discrimination or your students have been subjected to any of this sort of vitriol or harassment or double standards that unfortunately exist on campus, please, we implore you to reach out. Our legal chairs, such as Matthew, and our staff and our fantastic legal volunteers, such as Aaron Rosenberg, are not only happy to help, but they want to help, as we see. And Professor Cotler, thank you again. I remember meeting you at APAC that time, very briefly, 2 days before this whole thing went
pandemic, right?
And I was thinking to myself, we would love to have Professor Cotler involved with something where really we can engage our law students. So I think this is the first of many programs and initiatives we'd like to do specifically tailored to Canadian law students, because obviously, the law here is very different than a lot of the programs we see that are happening in the States. And I think for our students, they don't want to talk about Title VI, but they want to talk about Section 319 and the Ontario Human Rights Code and so many of the issues we discussed today. So really, thank you to everyone who joined us. If you have more questions or if you want to learn more about Hasbara, please feel free to reach out to me. And Shavua Tov. Thanks so much again.